Thanks, Tamara. It's my privilege and a pleasure to introduce Georgie Haysom, who is the General Manager of Research, Education and Advocacy at medical indemnity provider Avant. Avant does look after the vast majority, I believe, of Australian medical practitioners. She's worked as a health lawyer for over 30 years, assisting, advising and educating doctors on a wide range of medico-legal issues, including representing doctors in medical negligence litigation. She's also been very helpful in providing me with members of her education group to provide advice at meetings of the Australian Society of Anaesthetists and the College of Anaesthetists too. For the last 10 years, she's worked in advocacy and public policy, and she's really just the person to speak to us about privacy law. What does it mean to clinical registries?
Thank you very much, Ken, and thanks everyone. Can you all hear me? Can I just have a thumbs up that you, yep, awesome, great. Sometimes Teams decides to stop up, as I'm sure you're all aware.
Yes.
Yeah, awesome. So Ken, shall I take it away? All good?
Yes.
Okay, awesome. Thanks so much. So as Ken mentioned, yeah, we're a medical indemnity provider. We insure around just over half of the doctors around Australia. So many of the clinicians who I'm sure will be giving information or providing information to your registries. Ken asked me to come and present to you today just to give an update on the changes to privacy legislation that went through at the end of last year, which impact organisations that hold health information. And we also thought it would be a good opportunity just to do a quick refresher, I suppose, of privacy principles, and I'll give you the rationale for that in a moment as well. But first, if I could just pay my respects to traditional custodians of the lands on which we're meeting today. I'm also coming from Gadigal land, and I pay my respects to elders past and present and extend that respect to Torres Strait Islander and Aboriginal people who might be here today. So what I'm going to do in this short presentation is just talk a little bit about the privacy and security landscape. This is the rationale for being up to date on privacy law. A really quick run through privacy law and the frameworks that apply. Then a bit of a discussion of what's so what for clinical registries, and then hopefully we'll have some time for Q&A. So this might be a little bit hard to see on your screens if you're using laptops and what have you, and I will provide a copy of these slides afterwards to Natalie and Tamara so that you can have access to them. But the healthcare sector is the highest reporter of data breaches to the Office of the Australian Information Commissioner. So under privacy law, there's a requirement to report to the Office of the Information Commissioner a notifiable data breach, which is a breach that might happen that has the potential to cause serious harm to individuals. And there's a mandatory obligation to report that. As I said, their health is the highest reporter. The OAIC produces a report every 6 months on notifiable data breach. And you can see there the sources of breaches, again, a little hard to see, but primarily there's they're mainly malicious or criminal acts. And also that's number one, and human error is number two in terms of the types of data breaches that are reported. The general cyber environment is such that there are targeted attacks on specific sectors, particularly the healthcare sector. And I'm sure you will have seen lots of media about healthcare providers being hacked or having data breaches. There was the Medicare hack, it was probably 2 years ago now. The Medibank hack, I beg your pardon. There's always news about some US healthcare system being hacked. So there's lots of sort of cyber threats in the environment. We've also started to hear about these AI-powered attacks and these phishing schemes where hackers get in through emails that are spam emails, and also a lot of the social engineering where they pretend to be people, so they can get into email lists and pretend to be people and send out emails, and that's how they get seemingly from a trusted person or a trusted organisation, and that's how they try and get people to click on their links, and that's how they get into their system. So I'm sure you've seen lots of media about those sorts of things, and hopefully in your organisations you will have done some training around security and phishing emails and how to identify them. That's one of the compliance activities that I'll talk about at the end. So there's lots of vulnerabilities in connected devices and systems. As I mentioned there, of course, we're probably all aware that healthcare data is really high value, and you know, there's lots of things going on where they're trying to, the business model of a lot of these hackers is that they lock up the systems using ransomware, try and disrupt the healthcare operations with a view to being paid the ransom, and then that's how they kind of make their money. And once the money's paid, they may or may not unlock it, but that's sort of the business model that they undertake. So a lot of threats to healthcare systems and databases, which is why that's particularly relevant to clinical registries. So onto privacy law. These are some general principles around privacy law as a bit of a refresher. So privacy laws apply to personal information. And personal information is information that is identifiable. A lot of people think that if you remove obvious patient identifiers like date of birth or the name of the patient, that's therefore been de-identified. But for privacy purposes, it hasn't. Personal information or information will be identifiable information if it's capable of being re-identified. So a lot of information that is provided in the healthcare system, particularly sort of interesting stuff. I mean, in the context of registries, I suppose some particularly interesting adverse outcomes relating to a patient, even if that information might be de-identified from the point of view of their patient identifiers being removed, it might nevertheless still be identifiable. I hope that makes sense. So I think the key point to take away from this is that you should basically assume that most information is going to be capable of being identified and should therefore be subject to privacy protections. Privacy laws focus on collection, use and disclosure of information primarily, also on the integrity and quality of the data, and also on accessibility. So individuals do have a right to access information held about them, and there's only sort of limited circumstances in which a patient could be or a person can be denied access to information that's held about them. The privacy laws outline transparency and governance requirements for organisations holding personal information, and I'll go into that in a bit more detail. Health information is deemed to be sensitive information, so it has a higher level of protection, and that's sort of all health, almost all health-related information. So, you know, if we're talking about a private medical practice, even the information around sort of appointments and things like that, whilst it's kind of administrative information, or it might just be a patient's name or the fact that they've been to see a clinician, that's considered to be broadly health information, therefore needs to be protected, even though it might not have the more sort of sensitive information about the patient's clinical care. So it's very very broadly defined, I suppose. And importantly, interferences with privacy, so privacy breaches or cybersecurity issues that lead to privacy breaches are actionable in the courts. And I'll give you a bit more detail about that, because some of the changes that came in at the end of last year have changed the kind of threshold for actionable privacy breaches. All right. Complicated situation with the legislative frameworks around this country. We kind of joke, and maybe this is the bit that needs to come out when you're editing this, Natalie. We kind of joke at our organisation that one of our key advocacy points would be to abolish the states, because we have this federal system of state legislation and federal legislation. In the privacy space, we have the Commonwealth Privacy Act that applies to Commonwealth government entities and the private sector. In the states and territories, we have the information privacy legislation that applies to the public sector, but private sector organisations are covered by the Commonwealth legislation. And then in Victoria, the ACT and New South Wales, there's specific legislation that applies to health records and health information in those jurisdictions. So it's a bit complicated, but the good thing is that generally the principles are the same across all of those legislative frameworks. So I'm going to talk in a moment about the Australian privacy principles under the Commonwealth Privacy Act. There are similar principles in the information privacy legislation in the States, and also those health records information privacy legislation in Victoria, ACT and New South Wales. So, so you don't have to know exactly which legislation applies. It's the principles that you need to comply with, really, at a sort of high level. The other thing to note that there are some small businesses generally aren't covered by the Privacy Act, the Commonwealth Privacy Act, unless they have an annual turnover of over $3 million, but that doesn't apply to health. So if you're a small health business, you still have to comply with all of the privacy requirements, even though you're a small, you have a turnover less than $3 million. And that's part of that issue around health being considered to be particularly sensitive and therefore needs higher level of protection than other personal information. So that's why I've got that diagram there with the confused looking person, because it is a bit of a mess in terms of what legislation applies where. Okay, so in relation to the Commonwealth Privacy Act, which is the one that was amended at the end of last year, it's generally what's described as principles-based legislation. So they have a principle, and then the guidelines detail more information about how that privacy principle should be applied in practice. So it's sort of good because there's a bit of flexibility, but also can lead to a bit of matters being open to interpretation in terms of how privacy legislation might apply when it comes to minutiae. At the highest level, I think the way I describe privacy legislation is it essentially gives control to the person whose information it is over what happens with their information. So your information that you give to a doctor, if you go and see them, you have control over what happens to that information, and the practice, the organisation that holds that information has to comply with all of these things to make sure that that's given the appropriate protection. When you drill down into privacy law, it's actually really complicated in terms of how the guidelines apply. So if you do, a key message I suppose I have is if you do have any doubt about how whether there's a privacy issue or whether there's some concern about whether information should be disclosed to a third party, then seek advice about that, or go and have a look at the Office of the Information Commissioner's guidelines, which are very helpful but quite long and detailed. So the Australian privacy principles cover those things there I mentioned before as well, and are on the slide: collection, use and disclosure of personal information, the governance and accountability rules, integrity and correction, and the rights of individuals to access that information. And it applies to all organisations holding health information, regardless of size, as I mentioned. Now, again, this is going to be a bit hard to follow, but it comes from the Office of the Information Commissioner. And as I said, there'll be a link to this information at the end, and I'll send that out to you with the slides. So there are 13 Australian privacy principles, and I'm just going to read through them because it's a little bit difficult, just so that you can get a bit of an understanding of the sorts of things that are covered in the Australian privacy principles. So the first one is around open and transparent management of personal information. And this is where organisations' privacy policies come into play. So you will have, I'm pretty sure, clinical registries will have a privacy policy. It's up at the bottom of the website, or something that, or the organisation that runs it will have a privacy policy about how you manage information that you have collected and that you're using in that registry. So that's in relation to open and transparent management. That's so that patients or people whose information you hold know about how that the privacy of that information is protected and how the information is managed. Anonymity and pseudonymity won't really apply, but that principle is that if you can provide a service or a good or something to a person anonymously so that they don't have to give their information, then you should do so, which is an interesting one to think about when you're in your daily lives dealing with organisations. I can't believe how many organisations ask you for your name and address, or things like that. Sometimes your date of birth, just to provide, some sort of service, which I'm sure they could provide you with anonymously. So that's another one. Collection of solicited personal information is how you collect information that you want to collect, so that you have asked a person that you want to collect. Unsolicited personal information probably doesn't apply so much to you, but in the clinical situation, it might be a GP might get a call from a family member, for example, of a patient saying, I'm really worried about my mother who, isn't driving really well. And I want you to do an examination of her to check whether she's in some sort of cognitive decline or something like that. So that's unsolicited information because it's just come out of the blue. So as I said, probably doesn't apply so much to you guys, but you can tell me later on whether that would. Notification of collection, that's about your privacy notice and your privacy policy. Use and disclosure is how you are going to use and disclose it. So for the clinicians that collect the information that come to you, they have to tell their patients they're going to disclose it to you because you're a third party. So that's an example of that. Direct marketing is probably pretty straightforward. You need to get specific consent for that. Cross-border disclosure of personal information is where information is disclosed overseas. I understand most clinical registries will be, if not all, are all based in Australia, so that shouldn't apply. But if for some reason information is sent overseas, then there are specific obligations under that principle. Adoption and use of disclosure is government-related identifiers. That's just all about how you identify patients. So you're not supposed to use government identifiers as an identifier for a patient. Quality is about making sure that the information is accurate and up to date. Security is really important for registries, of course, because that's all about making sure that entities take reasonable steps to protect the personal information from misuse, interference and loss, and from unauthorised access, modification or disclosure. So that's where the cybersecurity piece comes into privacy legislation. And it's often said that privacy and security are two sides of a coin. They go together. Access to personal information is about patient access, making sure that that they do have access and they are entitled to, or not patients, but persons. People have access to information that's held about them. And then the last one, correction, is about making sure that if someone says you've got the wrong information, that you take that into account and correct it where appropriate. At the end of last year, there were several changes that came through to the privacy legislation, the Commonwealth privacy legislation. The first one there is about automated decision making, and this is all around AI actually, and AI where it's being used to make decisions on the part of the organisation. So most AI, I think at the moment, well, not most AI, but a lot of AI that's being used in the clinical world is not automated as such, so it's not making decisions, but it's assistive. So it's assisting clinicians and others in their practice. So, there's, how you define automated decision making is a bit of a challenge, but certainly our advice would be, even if it's just assistive and you're using AI to assist you in the work that you're doing, it's probably a good idea to put it in your privacy policy, even though it's not making decisions like the robo-debt sort of example where it was being done. Decisions were being made without sort of human oversight. The next one there about taking reasonable steps to protect the security of information specifically now includes technical and organisational measures. And this is intended to refer to the cybersecurity risk mitigators. And the Australian Cybersecurity Centre, for example, recommends that all organisations that hold information follow the Essential 8. I don't know if you've heard of the Essential 8, but if you haven't, check it out on the Australian Cybersecurity website, Centre's website. So the Essential 8 are the 8 sort of security risk mitigators that the Cybersecurity Centre recommends businesses put in place to protect the security of information. And this is like multi-factor authentication, patching your systems, making sure all your software is up to date, all of those sorts of things. But that's now specifically in the legislation. There are also new civil penalty provisions for less serious privacy breaches. So prior to these amendments at the end of last year, it was only serious interferences with privacy that were subject to enforcement action by the Office of the Information Commissioner. They've changed that now, and I don't know the rationale, but one would imagine that perhaps the educative approach hasn't been sufficient in dealing with potential privacy breaches. And from that data I showed you before, we're still getting lots of privacy breaches notified to the Information Commissioner. So they've now introduced these new civil penalty provisions for less serious privacy breaches. So an example of that might be even if your privacy policy isn't up to date, or you haven't reviewed it to make sure that it's sufficient and it's not compliant, then that might be something that you could potentially get an infringement notice from the OAIC for. The whitelisting of overseas countries that provide substantially similar privacy protections is about that provision, that principle I mentioned before. If you're sending information overseas, the previous situation was you had to do all these sorts of things to make sure that the country where you were sending the information had similar privacy laws to Australia, and so the information would be sufficiently protected. That's sort of the onus on organisations to be able to do that and to understand that is pretty crazy. So what they've done now is to say that there will be regulations which will say that these countries have sufficient privacy protections, and therefore you don't have to worry about doing all of that stuff under APP 8. So therefore you can rely on, if you say England or the UK is one of the countries that's been whitelisted, then you can be satisfied that that country has sufficient privacy protections that you can send it overseas without taking any further steps. Then the other one, this last one, is something that's caused quite a bit of discussion amongst the health sort of world and also the legal world, actually, is this new legal cause of action. It's called a statutory tort for breach of privacy. So tort law is basically around civil wrongs and things that can go wrong that aren't sort of criminal, I suppose. Up until recently, there hasn't been a tort of privacy in this country. So you couldn't really sue for breaches of privacy where, you know, overseas you hear about those stories with people, celebrities and what have you, suing newspapers and others for invading their privacy and interfering with their personal lives and things like that. You haven't been able to do that in Australia up until now. This new provision allows people to bring actions for serious invasions of privacy, which amount to, they call it intrusions into seclusion. So that's an invasion of an individual's sort of personal privacy. But the other one they've added is misuse of personal information. So where this might apply in the clinical context is, say, someone has a bit of a snoop in some hospital records because celebrities come in to have treatment in the hospital, and there's been instances of this in various jurisdictions in Australia. And then, so they had a bit of a snoop, and then let's say they went and talked to a journalist, or they put it on Facebook that they'd had a look at the clinical notes of a celebrity in a hospital. That might be an example of a misuse of personal information, and if it causes, if it's serious, and then that could lead to an action for breach of privacy, and that action could be taken against the person who did the snooping. It could also be taken against the organisation that employs the person who did the snooping. So the organisations might be what's called in law vicariously liable for the actions of their employees if the employees are snooping and misusing information. Well, we're not really sure how that's going to play out because it's a new tort, it's a new cause of action in Australia. So we're going to have to see how it plays out. But there have been instances of that in similar laws in overseas, for example, in Canada and the UK. Okay, so what does that mean for clinical registries? So I think hopefully you will have thought about some things that might be relevant for you from a privacy perspective. The ones that I just wanted to pull out were when I looked at the framework for national clinical quality registries from last year and the operating principles there. The things that sort of struck me where the privacy laws and the framework is relevant is in relation to sort of data governance, and security compliance. All of those things work within the framework of the privacy legislation. And so they should all be consistent with them. As I mentioned, the privacy legislation is principles-based. So all of these sorts of things like the frameworks and the guidelines all should operate within that framework, that privacy framework. The framework will apply regardless of the source of the information and regardless of who the actual owner of the information is. So in the clinical registries context, the owner of the information might be the patient. It might be the clinician who sent the information to you. But once an organisation or an entity holds information and it's personal information, so it's identifiable, then that organisation has the responsibilities under privacy legislation to make sure that privacy is protected and that all those APPs are complied with. The privacy legislation that will apply will depend on the jurisdiction in which the registry is based. But as I said, the principles are generally the same across the board, whether it's the state-based legislation or the Commonwealth legislation. So the compliance pieces there are around making sure that you comply with the guidelines because they sit within that privacy framework, and they do actually refer to complying with privacy legislation within the jurisdiction in which they sit. Training staff to reduce the risk of privacy and cyber breaches is super important. So ensuring that people understand their privacy obligations and that they understand cybersecurity and ensuring that they don't, that they have a good awareness of cybersecurity. I think they call it a cyber-aware culture. Don't click on suspicious emails, protect your password, use multi-factor authentication, all of those things that can help protect information, because I would imagine that clinical registries have a whole heap of information and health data that would be of use to those bad actors out there. Implement access controls to prevent the unauthorised access to data and the misuse of data. Now, under the statutory tort of privacy, if someone snoops around and grabs a whole bunch of data and starts, for whatever reason, for malicious reasons or otherwise, releases that data somewhere, then the legal entity that runs the registry could potentially be liable for that. And for the less serious things, then you could be on the end of infringement notices and fines from the Office of the Information Commissioner if there's been some more minor privacy breaches that they become aware of. The last slide, second to last slide, is just a couple of resources that I've got there. We're about to produce some e-learning courses on privacy, which are for Avant members, but they're good if you've got any clinicians or if any of you are doctors and members of ours, you'll be able to access those. Otherwise, if you know any clinicians, they'll be able to access those if they're members of ours. The Office of the Information Commissioner's Guide to Health Privacy is detailed but good. So if you need any assistance on any of those APPs in terms of how they would apply in your circumstances, then they might be a good place to start. And then I've got the standard legal disclaimer and a QR code at the end. And I've only given myself 4 minutes left for questions, so I apologise for that. And that's our very quick run through privacy this afternoon. Thank you.
Well, thank you very much, Georgie. I think that was very clear. And there are messages there that everyone's got to take note of. And I think it'll be great to be able to read through those slides and have a copy of them just to check up from time to time, and also the other resources that you've mentioned. So I ask now if there are any questions. Julie Morrison's got one. Can you provide a link to the website?
Yes, absolutely. So what I'll do is I'll send around those slides and that QR code. I know I didn't leave it up for very long, sorry. I've got that QR code so in those slides, so I'll send that to you for sure. And I should be able to pull up a link to the website as well.
Okay. Christopher Reid?
Yeah, thanks very much. Georgie, that was terrific. I really enjoyed that overview. It's nice to kind of, hear it and reinforce a number of the things that we kind of struggle with in the registry sector. We know we don't always get it right. So it was really interesting to hear your presentation. I was particularly interested in the use of AI and just how that might be utilised in the registries sort of sector. What opportunities there might be for AI to not only in sort of analytical activities, but also potentially looking to facilitate whether it be trial recruitment or something like that. Have you had any exposure to that or any sort of experience with the use AI for good, not for bad, so to speak?
Yeah, absolutely. I haven't had specific experience in relation to registries and that sort of data, but we've done quite a lot of work on AI, particularly in the AI scribe space. So I don't know whether that's relevant to you guys, but I think there are lots of opportunities, particularly in terms of, as you mentioned, sort of looking at that data and analysing the analytical part of that. I think there's probably lots of opportunities to use AI for good in that space. As for other stuff, I couldn't really say, but I think the thing with AI, as we all know, it's moving so quickly, and I think new opportunities are coming up more and more. I think the main thing is that, particularly in that space of using AI for more administrative tasks and less kind of not diagnostic and all that kind of stuff, is there's no regulatory oversight of that. So then you do need to do a bit of due diligence to make sure that it's sufficiently safe. There are a lot of privacy issues with regard to AI, particularly those large language models that work, like ChatGPT and the deep, whatever it's called, all those sort of general purpose AIs work on a very massive database. And if you start putting information into those sorts of tools, who knows where that information is going. So doing some due diligence around, if you are going to use AI, it should be a closed kind of loop AI so that it just uses the data within your system rather than going out, because then that'll have some level of privacy protection. Then there's a whole bunch of consent issues around the use of AI as well. But I think there's lots and lots of opportunities. If you're going to use it, just do your due diligence first.
Thanks, Georgie.
Thank you.
Any other questions? I think we're going to have a large amount of resource material available for you to peruse, and if you're an Avant member, you might find a few people knocking on your door to get the Avant opinions on the new aspects of privacy. And we're very generous people. We Avant members will hand it out to anyone that needs it, cost-free, of course. Perhaps if I hand you back to Tamara now.
Yeah, thanks, Georgie. That was great. I think having a reminder for us is something that we need regularly, even though, privacy is probably a pretty dry topic for most of us. But anyway, so thank you so very much. I think it was really great to hear some of the things that have actually changed, and certainly some food for thought, given the fact that most of our registries or big registries are sort of binational. So we do actually send a lot of information. We collect a lot of information from overseas, plus we also send a lot of information overseas too. So that's certainly something to think about. And also something for us to think about is, are our registries actually covered by our organisational privacy policies, as well as, or should we actually be having something particularly for our registries? So I'm going to leave that with an open thought for people to think through and how you manage your own registries. Any questions that pop up from anybody, feel free to send them through. Natalie will put together the minutes of the meeting and send those out to the group, including the information about the symposium, the ACTA symposium coming up, some details about that as well. And so feel free to message us with any information that you might have or questions that you might want answered to. Thanks, everybody. Have a great day.
Thank you.
Thank you.